Hi, everyone, and welcome to this WR Immigration Attorneys webinar on visa and green card options for athletes. I hope you are all well, safe, and of course, sane during this crazy pandemic time. And delighted that you are all able to join us today, hoping that you'll find this webinar informative. Couple of quick housekeeping things just to get this started. If anyone has any issues hearing me or any problems with the screen, just send me a chat. In addition, if anyone has any particular questions, there should be an option at the bottom where you can kind of submit questions. If that doesn't work, just send me a chat through the Zoom chat side of things. Try and get to your questions during the presentation, or actually potentially right at the end. We should have some time for questions then as well. So to get started, I think we have a good number of people here, so I think we'll move forward with everything. Very first thing, give me one sec. Obviously, I've got to do the usual standard disclaimer here. This presentation doesn't constitute legal advice. It's for informational purposes only. For legal opinions, please schedule a consultation with one of our attorneys so that we can actually assess the specifics of your case and that side of things. A little bit about our firm. Wolfstorff Rosenthal is a full-service, technology-focused, top-rated immigration firm. We have offices in Los Angeles, New York, Oakland, San Francisco, Santa Monica, and Shanghai. So we kind of a little bit all over the place. We've been working with a lot of different clients, and we've done visas and green cards for a lot of different industries, including a lot for athletes and that side of things. Just got to go through the obligatory talking about our awards. You know, our firm has actually won several awards, been ranked as Tier 1 immigration law firm through Best Lawyers, top ranked in Chambers, this side of things. Moving on to myself. My name is Richard Yemm. I'm a partner with the firm, certified immigration and nationality specialist. Been working on these types of cases for a long time. If you have any questions, if you have to drop off at some point, or have a question that we don't get to today, feel free to email me. It's richard@wolfstorff.com, and I can kind of hopefully help guide you in the right direction moving forward. So moving straight ahead. As I mentioned, we're going to be talking today about the main visas, green card options for athletes, and also to some extent for coaches as well. There's basically two main non-immigrant visa, working visa options available for athletes. And the first one we're going to address today is the O1 visa. Now, this is a visa that is available for those with extraordinary ability in their particular field. Now, you may have heard of this visa in other contexts. There are other O1 categories, particularly for those in the arts, for those in the motion picture TV industry. This is typically the one that we use for actors, directors, that side of things. But today we're just going to focus in on the O1A as it relates to athletes. This is actually a much higher standard than the O1B for those in motion picture TV, for those in the arts. O1A actually covers not just athletes, but it covers scientists, professors, business people, pretty much kind of the whole gambit. But again, we're going to focus on the athlete side of things today. And it is kind of a high standard. And you'll see a little bit later some of the criteria, don't necessarily completely gel with the field of athletics, but it's kind of the best we've got, and we're working with it in that context. So we're also going to cover the O2, which is essential support personnel, which is where you can bring in potentially, if you have an athlete, you bring in a coach or someone along those lines to act as essential support to that person. There's also an O3 visa, which is a dependent visa. This is for spouse and children. Unfortunately, the O3 does not come with work authorization. So in these cases, spouse can come, potentially go study, go to school, this side of things, but cannot work during this period. So it's something just to consider. So a few of the O1 visa basics. Now, the main basic elements that I would always want to look at when you're looking at a new O1 and whether you qualify is, firstly, do you have the talent? Do you meet the O1 criteria? Secondly, do you have a petitioner, an employer or an agent, someone along those lines who's going to act as your petitioner for the purposes of your O1? The last one is, do you have available work? Now, one of the key aspects of pretty much any non-immigrant visa is they want to make sure that you actually have work coming up, that you're actually going to be working on things moving forward. You're not just coming out to hang out and be here. The idea is that you're in demand, people want you, and you're going to be working for people on different projects. So very quick overview of the process. There's filing forms. There's form I-129, I-129-OP supplement. These are the main forms that we use. The two service centers that we file these cases to, California or Vermont, which is actually not based necessarily on where you're located, but based on the petitioner headquarters. So if you're working through an agent that's based in New York, it's probably going to be filed through to the Vermont Service Center. Filing fees, right now it's $460, which is the base regular government filing fee, plus an additional $1,440 for premium processing. Now, a couple of things to add here. You may have heard about immigration struggling financially, this side of things. They are increasing their government fees as of October 2nd. The O1 filing fee is increasing quite a decent amount by about 53%, up to $705. So if you file the case, which chances are, if you're starting sometime soon, probably not going to be potentially filing until after October, it's going to be that higher $705 government filing fee. That's just your regular government filing fee. If you file the case with regular processing, there's no real guarantee of adjudication time. And they have been a bit inconsistent with some of them. They adjudicate very quickly. Others can sit for sometimes several months before you actually hear anything back. Now with premium processing, it's kind of one of these situations where money talks with the government. You pay them additional $1,440 and they adjudicate the case right now in 15 calendar days from receiving the application. And adjudicate can mean approve. It can mean issue a request for additional evidence, which they will sometimes do if they're not sure you meet the criteria, you completely qualify. And then if they do request additional evidence and you respond to that, they then have 15 days to make a final decision. Now, I mentioned there that right now premium processing is 15 calendar days. We're seeing reports that it's going to increase to 15 working days, which may not seem a huge difference, but you're effectively going from about 2-week adjudication to about more like 3 weeks. So that is something potentially from October 2nd moving forward. Again, just a reason just to try and get this filed as quickly as you can if you need to be out here sooner rather than later. Other requirements, advisory opinion, union consultation. We will cover this in a little bit more detail later. This is basically an advisory opinion from either the union in your particular area or a peer advisory, someone US-based that can basically say they don't have a objection to you obtaining the visa. So just something just to kind of keep in mind. Again, we'll go into that in a little bit more detail later. It is only advisory, so even if the opinion comes back and immigration and the union or whoever it is kind of objecting, you can still file to immigration, but it can make your life harder. So what is the O1 visa standard? Well, for those in the field of athletics, you have to be able to show you're an individual who possesses extraordinary ability in athletics. What does that mean? You basically are going to be trying to prove to immigration that you are one of the small percentage to have risen to the very top of your field of endeavor. So this can be kind of a hard one. I mean, how do you really demonstrate that you are within that small percentage at the very top of your particular position? Well, that's where the O1 criteria come in. Here is the list. Now, right now, if you have won, for example, gold medal, Olympic medal, something along those lines, you're probably good. You can probably just use that, show that you've won this major international award, and you can kind of ignore the rest of what I'm going to say about this, because at that point, you've shown that you've got one major international award. Clearly, you qualified for an O1. You're good to go. You can kind of switch off for the rest of this part. But if you're like the vast majority of people that don't have a gold medal or an Olympic medal of some kind, then you have to show that you qualify under at least 3 of the following criteria. I'm going to go through them one by one just to kind of give you examples of things that can and can't work for each one. One thing I did want to mention is we actually do, our office does have kind of a questionnaire where I can, if you can fill it out, I can kind of give you a free assessment of whether it looks like you qualify, whether you meet the standard. Feel free, if you're interested in that, to email me. I gave you my email address earlier, but it's richard@wolfsdorf.com. I can send that questionnaire over to you. You can fill it out, send it back, and we can give you a sense as to how strong your case is right now. Now, the first part here is lesser national or international prizes or awards. This is something that, you know, it's an award, or it's something that isn't, you know, a huge award, but it's something that should still count because it still shows that you have extraordinary ability in your specific field. Examples of things that can work here include things like if you're winning a tournament, if you've, I don't know, kind of ranked really high on something like that. It can sometimes be used as evidence of something along these lines. But keep in mind that student awards do not count. Immigration really does not like things that are considered a student award. If it's national award, if it's something along those lines, it can be used to meet that criteria. And again, we only need to hit 3 of these to qualify you for the O1. Now, membership in associations requiring outstanding achievement of their members. Now, this can be a tough one for athletes. You know, it's relatively straightforward in an active context where if they're a member of the academy or something like that. But for an athlete, we have argued successfully in the past for things like if you're able to show, let's say you're a member in a national team. So if you're actually, if you're a member of a particular national team for a particular sport, there's an argument there that you're a member in an association that requires outstanding achievements, because people aren't picked for a national team unless they've already kind of shown that they're extraordinary, they've done a lot of good things. So this can be an option. This can be something that can be pointed at and, you know, argued that this qualifies you under that particular criterion. Now, moving on to published materials. Published materials, this has to be about you. It really has to be about your kind of accomplishments in the field, and it has to be in major media. Now, it can't just be, hey, a newspaper published that your name in there somewhere, you know, like you just a list of results and you're listed in there. That's probably not going to be super useful. It can be, but what's a lot more persuasive in this area is if you can show an article about you talking about how you've taken the tennis world by storm or something along those kind of lines. If there's something along those lines, you have a good shot at hitting this criterion and kind of moving forward from there. One thing I would say on the press area, the published materials, is it can be really useful. I mean, you know, I speak to a lot of athletes, a lot of clients who, they've been busy really making sure that they're at the top of their field, that they're doing well, that they're winning the games, this kind of stuff. And they've often, had press opportunities, but haven't necessarily gone with it. But yeah, I think this is one of those areas where you can sometimes improve on this. If you get an opportunity to do an interview, if you're able to get some kind of article about you, doesn't have to be press here in the US. It can be press in your home country. Just remember that major media part. So it's the bigger, the better from that perspective. But if you can get press about you, then do it, because it can really help if you're looking to do an O1 down the line. Now, the next part here, the authorship of articles, not necessarily something that we tend to see with athletes, but definitely seen it sometimes with coaches. If you've kind of written articles about your specific field and it's scholarly and we can kind of make an argument along there, can be something that can work, but typically no. It looks like I missed out on judging there. So judging of the work of others, this can also be a pretty decent criteria for athletes. The idea here is you have to be able to show that you have performed as a judge. You've kind of judged other people in your particular field. And I've done this for a couple of different areas. One would be martial arts, where often there's a martial arts competition and someone, if they've got kind of a particular high reputation or standing within the field, they are given the honor or chosen to actually judge others in that field. This can be an area that you can kind of use and work with. And similarly, across the board, if you're a tennis professional, something along these lines, if you're given the opportunity to go and judge, this is a criteria that immigration tends to be pretty good with. If you're able to show that, you tend to have a good shot of being able to kind of hit this one. And that's really the key to a lot of these criteria. We have to be able to document it. Yes, a reference letter from an individual who can confirm that you did this can be useful, but the more we have, the better. So if we can show documentation, press articles, whatever it is, to confirm that you really did this stuff, it's going to be really useful, and it's more likely that you're going to be able to qualify under that particular criteria. So moving on to the critical role. Now, this one is one I really like. Now, it's basically, this criterion requires you to show that you've performed a critical or leading role for distinguished organizations. Now, this is something that, you can make an argument with regards, if you're on a national team, you can talk about the national team being a distinguished organization, and you, as a member of that team, perform in a critical role. You can also talk about a team generally. I mean, I'm a huge Dodger fan, so Mookie Betts is probably going to hit this criteria because he's both critical and leading to the Dodgers as an organization, but also to MLB, arguably, that, it's the bigger stars and this organization, you're performing a critical role for that organization. And this is something that you can qualify under. You can show that this person meets the standard on that front. Now, high salary, this one is often a tough one to prove, just because in a lot of situations, athletes may not necessarily earn, substantially high salary, generally speaking, but maybe there's tournament winnings, something like that. I mean, we actually do a lot of these athlete visas for people within esports. With those cases, there's often a lot of prize money. That's something you can use, again, to kind of show that you meet that particular standard. Original contribution of major significance to the field. This, at first look, looks like a very tough one, because it's not really as though, generally you're going to reinvent the way of playing baseball or tennis or come up with a different way. I've used it in certain cases. It is sometimes possible. I'll give you an example. Again, going back to kind of martial arts situation, we had an athlete who had a very kind of trademark move, a defensive hold. that hadn't really been seen before, hadn't really been used before. But they kind of changed that once they'd come up with it, shown it, it'd been successful a few times. Then you start to see other athletes kind of using it. And that can be an example of a way to, again, thinking outside the box, trying to figure out how what you've done contributes to the field as a whole, and showing that you qualify on that basis. Now, I wanted to add in comparable criteria here, because O&A for athletics actually does allow you to bring in other evidence that may not necessarily fit neatly into one of these other criteria, but is also pretty relevant to showing that you're at the top, in the top percentage of people in your field. And things like this, we can throw in things like, for example, if you have expert opinion letters, let's say there are other people within your particular field who are really high up, but can really kind of write you a good letter explaining that you're, the top, or someone they haven't seen anyone perform the way you performed, and these kind of things can be used as comparable evidence. And similarly, if you've got a particularly high ranking, these kind of things can be put in if immigration doesn't like it under the national, international awards. Again, it just comes down to being creative and trying to figure out, how your qualifications overall meet the standards, show that you're actually within the top % of the field. A couple of tips I did want to mention here. One would be that you can actually sometimes narrow the field to enable you to be pushed to the top of that specific field. So an example here would be, let's say, if you are at the top of let's say beach tennis. If you are at the top of generally tennis, that's easy, you can get the visa. But let's say there's a specific subset of tennis, such as beach tennis, where you are really high up within that very somewhat limited field. By narrowing the field, it helps to push you to the top of it. Because if there's less people in that field, there's less, there's less people in the field, so it's easier for you to be pushed to the top. But it's also easier for us to make the argument that you are within the top percentage in that specific field. So things like that can really help to strengthen your case and make it so that they're more likely to give you the O1 visa. The last thing I did want to say on this particular slide is really make sure that you can support everything you're saying. The current administration is really clamping down on immigration. You can't just tell them that you're ranked first in the sport or you won a prize unless you're able to evidence it somehow. Now that can be from, let's say, reference letters or press articles, this kind of thing. But, we've often seen situations where a league or a tournament has, since you won it, it's gone defunct. It's really hard to get evidence. This is where, if you're thinking about considering an O1 down the line, I think it's good to make sure you keep that evidence now. You kind of collect it, maybe get a letter, you get evidence showing that you actually, you did it, you won whatever it was. Make sure you have evidence, because there's a lot of times where down the line, when you're filing this case, you don't have anything really to prove that you did it. So, moving on, the petitioner. A lot of people think that the O1 doesn't require an employer, and that's not entirely correct. In some situations, so the O1 can be done in two different ways. It can be done through a straight employer as your petitioner, as your O1 petitioner. This would typically be, for example, going back to the Dodgers, if Mookie Betts is going to work for the Dodgers, he's employed potentially by the Dodgers, and therefore they've kind of got that employee relationship, and he's able to work for them. Now, the issue here is it's limited to employment with that petitioning employer. So if you have your petitioner be the employer, then you can only work for that particular company. That isn't necessarily a huge issue with certain situations, but it can be in others, because If you're more of an individual athlete, you need to work for other employers, other sponsors, this kind of thing, you wouldn't be able to do that without potentially doing a loan out or doing something along those lines, or getting a new O1 petition for that new employer. So this is where agent as petitioner comes in. The agent as petitioner, this is where you have potentially your sports agent or something like that. And again, this is more with regards to the individual athlete. The sports agent would act as your petitioner. They would basically file the petition for you. But you would still, even in this situation, you would still need to be able to show you have projects lined up. So you're not just being, sponsored, petitioned for through an agent and you don't have any work lined up. You actually do have work upcoming. And this is something immigration can hit back on and scrutinize, is really making sure that you have an itinerary, you have names, dates, locations of the events, the tours, the events you're going to be a part of. That's what you're going to need to be able to show. And this is something particularly right now, we're seeing immigration scrutinizing extra carefully because of COVID. For example, a lot of the sporting events have been canceled. So this is something that you do want to make sure you have enough evidence to show that these events are actually going ahead, have been confirmed, and everything from there. One thing with regards to the petitioner I did want to add here is that the petitioner is technically liable for reasonable costs of transportation home if they terminate the relationship with you early. So, we often get the question, well, my agent doesn't want to do it. They think they're going to be liable for a lot of things. There isn't a huge amount of liability other than that in terms of, making sure they're able to pay that reasonable cost of transportation home. And I guess a tip here sometimes is when you're talking to them, ask them if they can act as your petitioner. That tends to be a little bit different if you're asking them to act as your sponsor, because sponsor conjures up ideas that if you run into medical issues or criminal issues here, they're somehow going to be on the hook, and that's not the case. With these cases, it's very much kind of an employer kind of situation, and therefore they're very limited on their liability, and acting as petitioner, they tend to be more willing to do that. So a little bit about who can actually be an agent. Now, technically, they have to be in the business as an agent for the petition. But this actually only means that they have to be authorized to act as an agent for the other employers. So if you have these other projects, you've got these other sponsors that are going to be kind of effectively your employer, they're going to be the ones paying you during this time. We have to just show that this agent is acting as an agent for the purpose of filing the petition. This is normally established pretty easily by showing what we call permission slip language from the employers. So if you have a couple of different sponsors, as long as the contract or deal memo that they're giving you explains at the bottom somewhere like, hey, I hereby authorize agent to act on our behalf for the potentially sole purpose of filing a US immigration petition, that side of things typically is going to be fine on this front. Now, moving on to what is an event. This can be kind of a tough one. But the good thing in the case of an O1 athlete is it can be just the duration of your contract. So if you as an athlete have a contract with a sponsor that's good for 3 years, you could be good. Because the O1 maxes out at 3 years. They can only give you 3 years at a time. But if you only have a contract that's good for 2 years, that only shows that you've actually kind of got employment, got work for that 2-year period, they may only issue you a visa for the 2-year period. So this is where I mentioned here, it's useful if you can to try and, include anything that you are likely to be doing here. If you have additional events, additional tours or anything else like that, try and show them, because that can hopefully show that you cover the full 3-year period to get that full 3-year validity on your visa. This typically, we don't see be too much of an issue for athletes, because typically you have the same schedule of tournaments, events each year. So it's really just a case of, hey, I do this every year, and these dates pretty much just continue every single year. Obviously, right now, it's been a lot tougher because of the COVID situation and events being cancelled, but hopefully that's not going to be for too much longer. Couple of issues regarding gaps. What this legalese here basically means is it's okay to have gaps. If your itinerary isn't kind of filling every single day of the next 3 years, that's not going to be a huge issue. If there's a couple of gaps here and there, which is often the case, particularly if you've got an international type tour where you're going to be spending some time in the US, some time abroad, immigration doesn't really matter, doesn't really worry too much about that. As long as the activities are related enough, there isn't a huge gap between the events, you tend to be fine and they can still give you the full 3-year validity on the visa. So just to kind of starting to finish up on this O1, we'll move on to the P1 very shortly. Couple of things with extensions, you can technically extend the O1 visa indefinitely. There is some issues. Sometimes they will only give you 1 year on an extension, particularly if it's just the same event or activity. But in certain situations, if it's a brand new event, brand new potentially employer or whatever the situation is, you can often get a 3-year extension and go through from there. The advisory peer opinions, this is something I'm going to address more in the P context, but this is something where you just want to make sure if there is a union in your particular area, you can get a letter from them. Again, this is the US based side of things. If you can get a letter from them saying they don't object to you, they think you meet the standard, this side of things tends to be all good. I won't dwell on this too long, but be prepared for your visa interview when you're applying at the consulate abroad. I mean, technically the officer isn't supposed to really question the approval of your O1. So let's say we file an O1 here, we get it approved, you take your approval notice, you go to the consulate. Don't go thinking it's just a rubber stamping situation, because that officer, as much as they're not supposed to question the approval, they can ask additional questions. They might want to see, do you really qualify? They can kind of look into it a little bit further. And certain embassies have been a lot tougher on this. For a while there, London was very tough on these O1 visa interviews. You really wanted to make sure you were prepared and you knew exactly what you were going to be doing and everything else when you went in there. A few issues I did want to mention that we're seeing just right now because of the current pandemic. We've seen, I guess, 2 main issues. One is that consulates are closed, or they're starting to be reopening now, but they have been closed for quite a while. So getting an appointment can be quite tough because there's a lot of backlog, a lot of people wanting to get appointments. It can take a while. Now, hopefully, by the time we're moving forward, that backlog will have been addressed and you'll be kind of going through the regular process of being able to get an appointment within a few days or so. The other issue that we're seeing right now is with regards to the travel ban. This is typically, particularly right now with the Schengen countries, the UK, while the O1 and the P1 visa were not included in the list of specific visas that were banned under the presidential proclamation through the end of the year. Those only applied pretty much to H's and L's. Because the Schengen UK area COVID travel bans still apply, they're giving issues. They're kind of canceling visa interviews if you're subject to that Schengen. If you're trying to come from Europe, for example, they're canceling visa interviews or potentially even refusing the visa at this point, which is frustrating because, technically you only need to be able to show that you weren't in the US, weren't in one of those countries within the 14 days prior to entering the US. So we had a lot of people who had valid visas leaving Europe, going to a third country to quarantine there for 14 days and then entering the US. And that's okay. That's seen as quarantining in a different country. But the consulates right now are sort of not really too okay with that. They are refusing the visa on the basis that, right now you don't have the ability to travel to the US. So unfortunately, what this means is possibly until this COVID travel ban is lifted, if you're looking to apply for one of these visas at the embassy or consulate, you may need to be able to show you qualify for a national interest exception. which is typically limited to humanitarian travel, public health response, national security, these kind of thing, that can be a tough one, but something just to bear in mind, particularly right now. The other thing to keep in mind is that right now, even if you're in a country that isn't banned for travel to the US, because of COVID, a lot of the officers will know that there aren't really too many projects going on right now. You know, they can do a quick Google search and they can see that events aren't taking place. So you're less likely to be able to get the visa to go to the US if those events aren't taking place. So just something else just to keep in mind. And if you're able to show that these events are going to happen, bring additional evidence, that can be useful. So I'll really quickly go through O2s. This is essential support personnel for the O1 principle. You basically have to show that you are an integral part of the O1 actual performance, you have critical skills and experience with them, and you have a foreign residence you have no intention of abandoning. So this is a whole separate petition. California, we have seen give additional questions regarding the essential nature of family members. We've seen this come up often in the case of younger athletes. You know, often very young athlete, unfortunately, if they get the O1, their parent doesn't get a dependent O3 visa. But in a lot of those situations, we've been able to get a parent an O2 if that parent is, for example, managing their career or coaching them or something along those lines. You can sometimes apply for an O2 to allow the parent to come in. Otherwise, they're going to have to look at getting a tourist visa or something like that. So why would you apply for the O1 and not the P1? The P1, which we're about to get onto, P1 is a much lower standard, but the O1 just requires you to show that you're coming to the US to work in your field, in your area of extraordinary ability. Whereas the P1 is going to require you to be coming in to perform at a specific athletic competition at an internationally recognized level. And this is something immigration often kind of focuses in on, is the event that you're going to be performing in at an internationally recognized level. And this can be a tough one. Another reason the O1 can be useful is if you're transitioning to a coaching position. Typically with the P1, you're going to be coming into as an athlete to compete, this side of things. If you're looking to switch to coaching, it's a little bit different because again, you're only needing to show that you're coming in to work in your area of extraordinary ability. If you are a huge, you know, you've had a great career in football or soccer or something like that, but they're bringing you in and a US employer wants to hire you to work in a more of a coaching capacity, more as an expert in a field, you can do that potentially on a O1, maybe not so much on a P. The professional wrestler is also a good example here. You know, back in my day, it would have been British Bulldog, or nowadays it's Page or someone like that. If the wrestler is coming into the US, there has been some pushback from immigration on some cases where they say that the athletic competition, it's not an athletic competition if the outcome is already determined. So in these kind of situations, maybe you'd be looking to shoot more for an O1 rather than a P1, and potentially even under a O1B, motion picture TV, lower standard, if it's seen as more like entertainment. The other reason for the O1 is it's actually a good platform for future green card application. Now, the green card we'll get onto later is a much higher standard than the O1, but the criteria are very, very similar. So if you've built up a strong case for at least 3 or more of the criteria we were talking about earlier, you can use a lot of that same evidence to make a good green card case for an EB1, where you can basically petition for yourself to get your own green card with no employer. So finally, we're moving on to the P1. The P1 is really kind of the main visa specifically for athletes. This one requires a high level of achievement in the field evidenced by a degree of skill and recognition substantially above that ordinarily encountered. It's lower standard than the O1. You do have to show that you're performing at an internationally recognized level, but it can be a little bit more straightforward than an O1 to get. Now, over the years, there's definitely been an expanded meaning of athlete, what qualifies. The big one that we've assisted a lot of people with is esports that I mentioned earlier. Things like Fortnite, League of Legends, these kind of esport leagues are considered a sport. They're considered an athlete, so they can get a P1 visa to allow them to come in under this category. The P4 is the dependent visa, similar to the O3 we mentioned earlier. This is for a spouse or child of the athlete. Again, no employment authorization on this. The basics of the P1 visa, typically you're looking at a 5-year visa for individuals, potentially a 1-year for teams or groups. Same forms we're looking at, same filing locations, same fees. I mean, there's also a bit of a question here as to whether the filing fee is actually going to increase for P1s, but it does appear that it will be. So again, just keep that side of things in mind. Now, the criteria for the P1, you have to show as an individual or team that you meet 2 of these criteria. These include things like participating in a prior season with a major US sports league, international competition with a national team, if you've participated in a prior season for a US college. The criteria that tend to be a little bit more straightforward to get is some kind of letter from an official or major US sports league, statement from a member of sports media, and the ranking. If you can show that you're ranked in that particular sport, if you can show 2 of those, tends to be pretty good. Don't tend to have too many issues getting the P1. But again, somewhat subjective here, and immigration does sometimes push back on the statement or letter, just really trying to make sure that this letter does really explain that you're at the top of or you kind of meet the standard for the P1. There is also the ability to get P1 for, obviously for professional athletes employed by a minor league team, but also coaches and athletes who are part of an international league of 14 or more amateur sport teams. That's another option there, as long as the foreign league operates at the highest amateur level. And the participation in that foreign league will render you ineligible to earn a scholarship or participate in that sport at college in the US. In addition, significant number of players in that foreign league have been drafted by a major league or minor league US affiliates. So this is another option in terms of getting the P1 through, and also for amateur and professional ice skaters. Now with the Petitioner, a lot of this is kind of, you'll recognize this from the O1, somewhat similar from that. With the P1, it can be an employer. So similar to, a Dodgers employing Mookie Betts, again, that can act as a P1 petitioner, they're your employer. Agent, typically where the athlete's going to be self-employed or the employer is foreign. And can also, one addition with P1s is that you can actually have your petitioner be a sponsoring organization. This could be someone who isn't going to directly employ you, but assume responsibility for the accuracy of all the terms. So this can often be, if you've got a potential sponsor who's going to be, you're going to wear their logo during their time, this can be potentially a petitioner and sponsor for the P1. The regulations do require a contract with a major US sports league or team, or one that's commensurate with international recognition in that sport. So again, this is sometimes the kicker, the slight issue on these, is you have to show that the contract kind of talks about how this event that you're coming to do, whatever that sport is, it's kind of got that international recognition. Now the P1 visa considerations, I wanted to mention consultations. This really kind of comes down to who do you know. Unlike in some of the other fields where there's very specific unions, this is a little bit Wild West. There's a lot of different organizations, particularly like, for example, in boxing and these other areas. It really comes down to who you as the athlete know. Like if you know someone in a particular association, maybe the World Boxing Association, World Tennis Association, whatever it is, if you know someone there who's able to issue a consultation or give kind of a no objection on your career, that can be really useful and is something that would be required as part of this process. Individual athletes typically admitted up to 5 years with an extension up to 5 years. Technically, there is a max of 10 years on the P1, but you can potentially get beyond that by kind of leaving the country, applying for a new admission, a new 5-year P1, and go from there. You're not limited to, a 10-year period max throughout your career. Couple of additional things: if you're a traded professional athlete, basically your employment is authorized automatically for 30 days after acquisition by the new team. But you have to make sure that that new team files a petition, I-129, within 30 days of the trade. As long as they do that, you're able to continue working for them moving forward. A couple of minor points here: substitution of beneficiaries. If you have one beneficiary listed on a P1, but you need to change who's going to be coming over, you can do that relatively straightforward, submitting a letter to the consulate. So it's a little bit tougher now because of the consulate closures and this kind of thing, but it is possible. There is a method to do that. And again, consular issues, you are seeing issues with the consulates, sometimes reevaluating these cases, this kind of thing, just to keep that side of things in mind. Now, the P1S, there is very similar to the O2. This is for someone who is highly skilled, essential person who is performing an integral part of the performance of the P1. So again, this can be bringing out a coach or someone along those lines. Got to be able to show that these services can't be readily performed by a US worker, that they're essential to your successful performance. But this, again, relatively straightforward. P1S, normally the initial one, they're only going to give 1 year for the initial one. You can then extend potentially for the length of the time that the P1 athlete has available to them. But the problem here is, what if the P1 athlete leaves the country or gets a green card? Unfortunately, at that point, the P1S drops off. They're technically out of status. They can't continue. So this is something just to really always kind of keep in mind. If, for example, you're an athlete, you're looking to get the green card, your coach could be in trouble at that point. So I did want to mention this briefly. I always get the question, do I really need to go through all of this, the different criteria and everything to get a P or an O visa, or can I just enter as a tourist? Now, it's kind of one of these situations where not really. There are very few exceptions. If you meet one of these, you can come in on potentially a B1, or we'll see later a B2 visa, which are really the tourist, the business visitor or tourist visa side of things. But most of the time, you're going to need to get like an actual working visa, one of the P or the O, to actually allow you to work. Now, the B1 visa option, this is for professional athletes who receive no salary other than just prize money. In the US, that's okay. In addition, athletes or team members who want to come in as members of a foreign-based team to compete with another sports team can be allowed in these 3 situations. So this allows a team that's on tour to come into the US to do maybe an exhibition match, something along those lines, if they meet these specific criteria. The B2 visa option, this is for amateur athletes. And the issue here is that an amateur athlete needs to be one who normally performs without remuneration. You can't be a professional athlete abroad, but you're going to say, well, I'm not going to work when I come into the US, so I qualify as an amateur athlete. That's not how it works. You have to be able to show that you normally perform without, other than potentially a small allotment for expenses. You can kind of come in under this as an amateur athlete. As long as you're not going to be paid for performances, if you're just performing in a social, charitable context, something like that. Incidental expenses associated with that visit are okay. And there is a hockey exemption. There's a few hockey exemptions because of the NHL and because of Canada, this side of things. Amateur hockey players are allowed to come into, if they're asking to join a professional team during the course of a regular season or playoffs, for brief tryouts. So this is another exception that exists there. So green card options. The main one I want to talk about is EB1. Now this is a self-petition green card. I mentioned it earlier, the criteria are very similar, if to some extent identical to what we were looking at earlier with the O1, but it's a higher standard. You have to show you have a level of expertise, one of the small percentages you've risen to the top of the field. They're also looking to make sure you've sustained reputation for international acclaim, this side of things. You really want to be, if you get an O1A, you're on the way to this, but you really want to make sure you potentially strengthen your case as much as possible before you're applying for one of these. Now, the EB1, it can be sponsored through an employer, but what a lot of my clients prefer is to self-petition, because then you don't need to worry about your employer being involved in the process. You just file for it yourself. The idea here is you're so amazing that it would be unfair to restrict you to one employer, so you're going to apply for a green card on your own and go from there. So like I said, basically same criteria. You show your Olympic medal or 3 of the criteria. The one thing that's slightly different here is technically, even if you meet 3 criteria, they can still deny the case. You also need to be able to show that looking at the totality of the evidence, you've demonstrated that you meet this standard. So typically, if you're meeting 3 criteria only, probably not the strongest case. You probably want to try and hit maybe others and really make sure that you have, you showing comparable evidence. You just show that the totality of evidence shows that you qualify. There's also a kind of a slight national interest part of this, but they don't tend to look too heavily about that. So I wouldn't worry on that front too much. EB1 can also be very useful for an athlete who's turning into a coach. Often if you get older, you maybe can't actually compete anymore. So you're looking to turn more into coaching. And this is okay on EB1. There's been kind of talk about this, and really the kind of the final answer appears to be, as long as you were relatively recently an athlete and you had quite a decent amount of acclaim as an athlete, and you've sustained that acclaim upon transitioning to coaching, then you are able to kind of still apply as a coach. So the issue here in the past was we would often see, a great, hockey star or someone like that who'd done amazing as an athlete, but turning to a coach, and they're asking for an EB1 to allow them to come in and work as a coach in their field. Immigration was sometimes kicking that back and saying, well, you've shown you've got extraordinary ability as an athlete, but not as a coach. So this allows kind of you to somewhat seamlessly transition across from being an athlete to being a coach. And the last one, if it's here. Yeah, last one I did want to mention, EB2 Schedule A Group 2. This is a little bit of an unusual area, but we can sometimes squeeze you under this in terms of getting a green card on the basis of exceptional ability in the arts. There was a case, Matter of Masters, that basically found that golf is in the arts because it's a form of entertainment. This particular category does require an employer to petition. They have to pay prevailing wage for the position. And there's a couple of things you have to meet in terms of exceptional ability criteria with Department of Labor and with immigration to meet this. So it's not something we see a huge amount of, but it can be another option. Now, I'm aware that we're running out of time, which is perfect because we're ready for questions. If anyone has any, I'm not seeing any coming through just yet. But yeah, we've got a few minutes. If anyone does have any questions, I will strive my best to answer them. Otherwise, like I said, if you want to shoot me an email at richard@wolfstuff.com, either just general or specific questions, or if you would like me to send over the questionnaire so we can kind of give you a bit of an assessment, I'd be happy to do so. And yeah, not really seeing any questions right now, so I think we should be good. Awesome. Well, thanks everyone for logging on. I hope you found this informative, and yes, please do shoot me an email if you have any other specific questions, and we'd be happy to help. Thanks a lot.